Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book from Ashgate Publishing, which is an interesting one, looking at legitimacy, legal development and change, with a subtitle, Law and Modernization Reconsidered. This is the book here. It's been edited by David K. Linnan. That's the spine and that's the back. It has a lot of detail. It's quite a heavy book. It's got something approaching about nearly 450 pages. There's an index at the back. You can see there's quite a lot of reference material, which is to be expected in this sort of publication. You've got standard chapter headings, which you can see there, and the individual contributors have put their points forward. There's a narrative as such with headings, and you've also got some footnotes and then references at the back. And at the front of the book you've got the various content sections, and you've then got some figures and tables, of course. Then you've got a list of the very large number of contributors who've put their names forward, then their acknowledgements as well. And then do read the basic introductory chapter by the editor, which sets the book out. The book is a detailed book, and it's not the easiest to understand to some readers. My wife and I have given it a review, exploring a continually evolving field of inquiry, the rule and role of law in the developing world. And that's really where we're looking at issues today, jurisprudentially. What we say is this: recently published by Ashgate, Legitimacy, Legal Development and Change presents a collection of articles and essays which set out to explore, analyse and define the often complex and wide-ranging area of what we would call comparative jurisprudence. That means the legal development in the developing world of this type of philosophy of law and legal theory. The book brings together the work of 26 academics and scholars from top universities and institutions worldwide. And in the words of the editor, David Linnan, the book explores overlapping themes, asking how legal development and change actually works, and focusing on specific examples of legal systems, mainly taken from non-Western jurisdictions in Asia, Africa, the Islamic world, and additionally South America. It's an interesting book because in common law jurisdictions, the common law often makes the cases and establishes the precedents directly. Obviously there is the use very much of statute law in the United Kingdom, which of course overrides the common law. But what we have with the creation of the common law is the development largely by evolution rather than revolution of law and legal systems, although there have been some quite explosive revolutions along the way, even with the development of the common law. Bearing all of this in mind, the book therefore is interesting in that it is a jurisprudential collection which points the way forward towards legal philosophical thinking from a global perspective, now and in the future. And I think that is what its great relevance to us today is. There are many learned articles in the book, grouped under various categories, from changing the ROL narrative, notice the words here, ROL being rule of law, to international law as legal development subject, looking at things like the Human Rights Court and various other matters. The various contributors, all with impressive academic and professional credentials, appear to discuss the multiplicity of issues involved from an entirely objective, empirical viewpoint, without any obvious political or partisan bias, and I think that's to be welcomed. I certainly thank Ashgate and the editor for bringing this work to our attention. I think it's very useful for anyone studying jurisprudence to know of its existence, and it's a work which should certainly be well worth referring to should you be writing any papers on the subject. Thank you to all concerned. Bye bye.